So roll call, please. Roll call, please.
Chair Bundy,
Here.
Commissioners Cassidy,
Here.
Daniels,
Here.
Vice Chair Jackson,
Present.
Commissioner Stuland,
Present.
Commissioner Vance.
Present.
Thank you.
So item 4 is presentations and commendations. For subsection A, we have a presentation by the City Attorney's Office on the Brown Act and the role of the commission.
So Manny, I need you to put up the slideshow if you could, please. There we go. Good evening, Commission members. My name is Randy Reisner. I'm the Chief Assistant City Attorney, and I'm going to be providing you a presentation this evening about the Brown Act and some other laws that affect how the Commission operates and what you can do legally. I'm not going to get into tonight what the role of the commissioners are because the presentation's already going to be long and you've got other stuff to do tonight. We'll pick that piece up another evening, okay? So with that, we're gonna dive right in. Okay, why won't it change? Oops. There we go. Okay. So there's a law in California called the Ralph M. Brown Act that deals with transparency and how public agencies operate meetings. It was enacted in 1953. It's named for Assemblyman Ralph M. Brown, whose picture is right there on the slide, and he's the one who authored the legislation. It was actually put in place in response to a series of articles in the San Francisco Chronicle that were called Your Secret Government, which revealed that secret meetings were common for public agencies. While the biggest culprit called out in that article was special districts and other non-city agencies, it was still common at that time for city councils to not notice where or when meetings would be, or to kick out members of the public when they decided to discuss something they felt the public shouldn't know about. Sometimes officials would publicly vote one way, then meet in secret later to change their votes. Since 1953, the Brown Act has evolved under a series of court decisions and amendments, but the central rule has not changed since its passage. Well, it would be nice to get to the central rule. There we go. So the preamble of the Brown Act says this, and I'm just going to read it to you. The people of this state do not yield their sovereignty to the agencies which serve them. The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments they have created. So the basic principle behind the Brown Act is transparency. And transparency is something that's essential to a democracy. And this is the initial language in the Brown Act on the slide. All meetings of the legislative body of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency except as otherwise provided in this chapter. All right, so these are the topics that we're going to cover tonight. Who does the act apply to? What's a meeting? What rules apply to meetings? And I know those sound kind of simple, but they're really a lot more complicated than you might think they are. Agenda requirements, and what are the remedies for violation of the Brown Act? who's subject to the Brown Act? Who does the Brown Act apply to? What people are groups of people? It applies to legislative bodies, as that term is defined in the Act. And this includes any body that has decision-making authority, whether it's elected or appointed. This board is, of course, appointed. You are a legislative body under the terms of the Brown Act. So, for example, planning commissions are subject to the Brown Act. You're subject to the Brown Act. Virtually every board and commission the city has is subject to the Brown Act, regardless of whether the members of those boards are elected. The Act also applies to what are known as standing committees. Standing committees are subcommittees appointed by boards and commissions that deal with a special topic that last indefinitely. Those are standing committees. So you might appoint a standing committee here to deal with a specific housing issue that you want to meet on a regular basis and to come back and bring reports to you about the issue, and it has an indefinite term. That's a standing committee. It's subject to the same laws and rules that you are under the Brown Act. On the other hand, ad hoc committees are not subject to the Brown Act because those are typically created for a short term, for just one reason. For example, maybe there's a specific report that was done by a consultant for the board, and you wanted a subcommittee or an ad hoc subcommittee to review that and come back to you with a summary of it and make recommendations about it. That would be a single purpose. They would dissolve once that task was completed. So they would not be subject to the Brown Act as long as they had members that were less than a quorum. So a quorum for you is 4 people. Same with a standing committee, if a standing committee has a quorum. But an ad hoc committee with a quorum would be subject to the Brown Act then. So a legislative body, we just talked about this, doesn't include ad hoc subcommittees of less than a quorum. Or a group of employees of the city, a group of citizens that is not appointed by the legislative body. We can get together as employees of the city and talk about anything we want to without providing notice to the public. What's a meeting? There are 4 elements to a meeting. Under the Brown Act, a meeting is a congregation of a majority of a legislative body, that's you, a legislative body, at the same time and place, like we are here, to hear, discuss, deliberate, or take action on any item that's within the subject matter jurisdiction of the legislative body. So, a meeting is any gathering of a majority of members to hear or discuss any item of business. In earlier versions of the Brown Act, officials could discuss matters as a group outside a public meeting as long as they didn't make a decision. This is no longer possible. It's now illegal to do that. If a majority of the board wants to discuss items of business, then it has to be done at an open and public meeting that's noticed. Just a little humor here. It's one of those information swapping parties. This is where members of boards and commissions can get into trouble. So individual contacts, and we'll talk about that more in a bit. Individual contacts of less than a quorum don't count as a meeting, as long as you avoid creating serial meetings with other members, and we'll talk about that more in a bit too. Seminars and conferences, for example, a lot of people in the city attend a big conference each year called the League of California Cities. We could all go to that. All the boards and commissions could go to that if the city council wanted to pay for it. And going to that would not be a meeting, even though a quorum or more than a quorum goes to it, because it's open to the entire public, and the discussion there is limited to items of general interest to the public, and the members of the body wouldn't be able to discuss city business there. Oops, I jumped ahead of myself a little bit. Community meetings such as town hall forums, chamber of commerce luncheons, other community lunches are not meetings. But it has to, again, be open to the public and publicized in some way as such. For example, a homeowners association holding a meeting, they're usually not open and not publicized, so they wouldn't qualify. You wouldn't be able to go to that. But my advice when you attend community meetings is to avoid any direct participation. In other words, it's okay to say thanks for the punch and cookies, but don't get into a discussion about your business, what you do on this board, because you run the risk, especially if there are 4 of you there, you would run the risk then of potentially violating the Brown Act. Social events, generally not considered a meeting. A majority of you could attend a social or ceremonial event as long as you do not discuss any city business, and that's kind of the key here. If you're not at a noticed meeting, don't discuss city business amongst yourselves if there are more than 4 of you, if there are 4 or more of you there. So you can attend the meetings of other legislative bodies like the city council or any of the other boards and commissions, but you still need to avoid discussing items of business for your board unless it's part of the scheduled meeting. So if planning commission is holding a meeting and it's possible to hold a joint meeting. That's been done from time to time. So you could hold a joint meeting with another board and commission if there was a reason to do that. I mentioned earlier, ad hoc committees, they're not subject to the Brown Act. Members of a legislative body who are not members of a standing committee, remember we talked about that a minute ago, you can still attend the meeting of the standing committee, but you can only observe it. You can't participate or discuss what's on their agenda. Otherwise, you're violating the Brown Act. So what would be an illegal meeting? Well, there are those meetings conducted in violation of the Brown Act. There's no exception that permits a majority of a legislative body to meet with staff in advance of a meeting for a collective meeting. Team building session, retreat, workshops must be noticed as well. So sometimes we'll hold a workshop to provide education to you about a particular topic. Those have to be noticed just like a regular meeting, and the public has to be allowed to attend. Serial meetings, what is that? A series of communications of any kind, direct or indirect communication, where indirect includes intermediaries and technological devices, by a majority of members to discuss, deliberate, or take action on any item of business or potential business. So the classic one is, I email one of you. You then in turn email the next one. She then in turn emails him, then emails him. We've just had a meeting. That's a serial meeting. You can't do that. Staff can talk to each one of you, so I can have a meeting with each one of you anytime I want to, but I can't tell the others what you said. All right? Neither can you. You can't go to the other person and say, hey, I just met with Randy and he said this, this, and this, and we're going to do this, this, and this. Because then it daisy chains again, and you end up having a meeting that you didn't intend to have. I mentioned this already. Staff briefings are fine. That's done on a fairly regular basis with the city council. Not as much with boards and commissions, but sometimes, yes, we do have agenda setting meetings and things like that, but it's always with far less than a quorum, usually 2 members. This is where staff briefings can get everybody in trouble. Again, if it's a collective briefing where I have at least 4 of you there, can't do that. Or it becomes a serial meeting like I just described where you guys daisy chain it up the line telling everyone what I said. Then it can get us in trouble. The other important thing about the Brown Act is meeting notice. And there are 2 basic requirements, and here they are. It has to be an effective notice under the law, and it has to have agenda items where each item adequately describes what you're going to consider. So the language has to be clear enough where a member of the public can pick up the agenda and say, oh, I understand, they're talking about this, or they're going to take action on this. An effective notice, well, we're going to get into that in just a second. 4 types of meetings, you're really only going to be concerned with 2 of them. Right? You're going to have regular and special meetings. The regular meetings are the ones where you have a set time and date for a meeting. I think you meet monthly, don't you? Yeah, so you have a set time and date for a monthly meeting. If there's additional business that you can't get done at your regular meetings, then your staff are going to do a special meeting for you. They'll poll you to see who's available on what dates and do a special meeting. There's an adjourned meeting. That's a situation where you have a meeting typically that runs a lot longer than you thought it would, and you can adjourn it to a date certain in the future. It's usually the next day, and there are special requirements for doing that. It's why we don't do it very often. And then emergency meetings, which you likely probably will never have, but that is a situation where something happens, a disaster of some kind, for example, an earthquake. The last one I was involved in was the earthquake that happened in Paso Robles when it was sometime in the early 2000s. We had an emergency meeting of the city I was representing in that county inside of a mobile unit, a trailer. Because everything was damaged and there was no power and things had to be done. So you can have emergency meetings in those circumstances, which means you don't have to comply with the regular notice requirements. So what is a regular meeting? In a regular meeting, the agenda has to be posted 72 hours in advance. The public also has to, and this applies to special meetings too, the public has to be given an opportunity to address you on any item that's on the agenda, including closed session items. Now, they can't come into the closed session if you have one, but they can address it before you go into a closed session and talk about it, give you comments about it. And any non-agendized item that is within the subject matter jurisdiction of the legislative body. So they can talk about things not on the agenda. That's typically done during community forum. So they can bring things and talk to you, but it generally has to be within your subject matter jurisdiction for you to hear it. Special meetings typically are called by the presiding officer or a majority of the members. Generally, in the case of our boards and commissions, what will happen is your secretary will probably call up the chair and say, hey, we have this happening, there's a deadline, we need to get this before the commission so that it can be reviewed and you can give your input. And then you would set a special meeting. Secretary would poll you all, let you know we need a special meeting, and ask you for dates or provide dates and see if you're available. Special meetings can be held with 24 hours notice. That means the agenda has to be posted 24 hours in advance of the meeting. And when I say posted, we post the agendas online, so there's electronic notice. And they also post it. You have a bulletin board that you post on, Shari? Yeah. So it gets posted physically as well. Has to be written notice to you, also to members of the press. With members of the press, they have to have requested notice of the meetings in advance. So what they do typically is send us a letter and say, hey, I want we want notice of any special meeting that you're going to have for the next year, and then we have to send them a physical copy of the agenda. That's not as important anymore now that everything is electronic, because they can pretty much see everything that gets posted online. Special meetings are a little bit different on public comment. They can comment on items that are on the agenda, but they cannot comment on items that are not on the agenda for the special meeting. At a regular meeting, they can during community forum. Special meetings do not have a community forum. We talked about this already. Adjourn meetings, I mentioned this briefly. This is not something that you're going to do very likely, so I'm not going to spend a bunch of time on it. Just know that it's there. So if you have a late meeting some night and you want to adjourn the meeting to the next day, you can ask about that. I'm probably going to suggest that we just do a new agenda instead of doing that, because if you adjourn it to the next day, I have to that night create a notice, go put it on the door, and then we have to also put it online again. So it's just as simple to do a new agenda with the same item and post it for another special meeting. Emergency meetings, I'm not going to talk about because that is not going to impact you. Here is the basic, the basic rule. Outside of a meeting, don't discuss items that are on the agenda, and at the meeting, don't discuss items that are not on the agenda. So you can't do that. You can, for example, if a member of the public during a community forum says, hey, we'd really like for you guys to consider that, you can provide some direction to staff and say, hey, we'd like you to explore putting that on the agenda at a later meeting. But you can't deliberate about it or have a big discussion about it if it's not on the agenda. Again, you can provide a brief response to comments from the public that aren't on the agenda. If there are questions from someone looking for clarification on an issue from staff, you can comment on that briefly. You can make brief announcements on or reports or activities of members. We have a section on the agenda for reports from members. That has to be brief. You can't go into, a long discussion there about anything. You can make requests of staff to provide reports in the future or to place items on the agenda in the future. So there are some suggestions, and these, again, are things that you likely will never see, but it's there, and I'll tell you briefly about it, because it could happen, and it does happen sometimes. Let's say that we prepare an agenda, it's posted, it's been up there for 72 hours, we get to a meeting, and all of a sudden we realize, hey, there's a mistake, something got left off. There's a deadline. If we don't decide tonight, something really bad's going to happen. You can, in that kind of circumstance, you can add that item to the agenda after the agenda was posted, but it requires action before. It has to require action before the next meeting of the body, and you have to approve doing that by a 2/3 majority. So that would be for you five votes. Now I keep forgetting to press the button to fill in all the bulleted items there. The Brown Act also requires public participation, requires that they be allowed to comment at meetings. It's because the focus of the Brown Act is promoting what we call the marketplace of ideas by involving the public in the governmental process. The Brown Act prohibits local officials from banning public criticism of its policies, procedures, or officials. So if you have a member of the public come up to the podium and criticize each of you, even though you might not like it, you have to sit here and take it and listen to them, because that's their right. There are also other provisions of state law that make statements made at a public meeting absolutely privileged, which means it's difficult to sue someone for libel or defamation. And that is to avoid what we call chilling of free speech. We want people to talk at a public meeting. We want their comments, we want their input, because this is it's their government, right? You can't require members of the public to register. For example, make them sign in at the door. You can ask them to, and most of them will voluntarily do that, especially if they're going to speak. You can ask them to fill out a speaker card. But if someone refuses to fill out a speaker card, you can't make them, and you still have to let them speak. They also don't have to provide their name or their address. They're allowed to speak anonymously if they choose to do that. The legislative body can adopt reasonable rules of decorum, such as time limits on speakers. It's okay to limit a speaker to 3 minutes. Sometimes if we're really busy at city council, they'll get limited to 2 minutes or even 1 minute I've seen when there have been, really a lot of speakers. The public can record the meeting, and that means video and audio. So if someone's out there with a video camera, you can't stop them. The one exception to that is if it's disruptive. If they're making a lot of noise, they're interfering with the operation of the meeting, then something can be said to them. Closed session. Shari, how often do you have closed session? Never. You've never? There are some exceptions to that that are likely not ever going to apply to you. I'll just tell you what some of them are really quickly here. Personnel issues have to be done in closed session because of privacy issues. Real property negotiations have to be done in closed session because we don't want to telegraph to the people that we're selling some real property to or buying real property from what our strategy is for purchasing that property. Litigation is done in closed session because we don't want to disclose the strategy for litigation against our opponent. So those are three primary things that would always be heard in closed session. So how's the Brown Act enforced? First, before anybody can sue for a Brown Act violation, they must give legislative body notice of the alleged violation and an opportunity to cure the violation. Ordinarily, notice must be within 90 days, and then the body, you, would have 30 days to cure. The simplest cure is to simply put the disputed item back on the next agenda, that is, renotice it and rehear it. And we've not done that here, but I've done that in my career at other places where a mistake was made and it was just renoticed and reheard, and that solves the problem. Then there's nothing else anyone can do. Another possible consequence is a civil action, that is, getting sued. Any interested person, which essentially means any member of the public, can challenge an action of the legislative body in court. Most of the time, the people who do that are citizens or newspapers probably more often. Courts tend to be very strict with the Brown Act, but the standard is what we call substantial compliance with the Brown Act, not absolute compliance. That means if we get essentially 90% of it right, we're good. The person suing has to show that the alleged violation resulted in prejudice, in other words, some kind of harm. And harm can be, we didn't have an opportunity to speak on the item, it wasn't agendized right, and therefore the members of the public didn't know what you're going to talk about. Had they known what you're really talking about, more people would have showed up. Those are the kinds of things that we frequently hear if something is not agendized properly. The Brown Act also has a criminal penalty. If the legislative body takes some action during a meeting with the intent to deprive the public of information, the members can be guilty of a misdemeanor. From a practical standpoint, though, that's extremely rare. But some district attorneys have been willing to allege these violations much more frequently than others. I've never seen it happen. I take it back. I did see it happen one time where there was an allegation made and nothing happened. I've never seen anybody prosecuted for it. But it's out there and it is possible. So if you are interested in learning more about the Brown Act, here's a website that you can go to, and they have a publication on there dealing with the Brown Act. There's an 85-page booklet that'll give you more information than you ever wanted to know about it. But it is a good resource, and it's available to you at that website there. All right, let's talk about public records because this can affect you. California has something called the Public Records Act that requires us, the public agency, to retain and maintain a public record and make most public records available to the public upon request. What is a public record? It is any writing containing information relating to the conduct of the public's business that's prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristic. So that means a writing, like this document here, is actually a public record. I'd have to give somebody if they ask for it. And a writing also includes email. It includes text messages, virtually anything. It includes recordings, both audio and video. It has to be conduct that's related to the conduct of the people's business, that's prepared by or owned by the public agency, or used or retained by the public agency. The Public Records Act was enacted in 1968, and it says that access to information concerning the conduct of the people's business is a fundamental and necessary right of every person in this state. In 2004, voters made this principle part of the state constitution. One provision added by Proposition 59 says, the people have the right of access to information concerning the conduct of the people's business, and therefore, the writings of public officials and agencies shall be open to public scrutiny. Public access laws serve a crucial function, primarily openness in government, because that's essential to the functioning of a democracy. Implicit in the democratic process is the notion that government should be accountable for its actions. In order to verify accountability, individuals must have access to government files. Such access permits checks against the arbitrary exercise of official power and secrecy in the political process. So we have a system here that we use called Next Request. Some of you might have used it or seen it. It's an electronic platform that allows the public to go and make requests for records. Those requests go to the city clerk's office. The city clerk is the person that's primarily responsible for responding to Public Records Act requests. The city of Vallejo has a very robust number of Public Records Act requests each year. Last year we had more than 1,300. And we have a full-time attorney in the city attorney's office whose only job is to process Public Records Act requests. And the reason we have to have an attorney do that is because there are several exceptions to the Public Records Act requests, including the attorney-client privilege. So everything has to be reviewed for those exceptions. If you're curious, that's what a request looks like on Next Request. It does impact staff time. Just wanted you to be aware of that. This is an old statistic here. That number's bigger now than it was when this was written. So one of the things that happens is, in this day and age, people use email for a lot of things. Well, most of the emails that are created by the city or by the housing authority are public records. Well, they're all public records. Most of them are disclosable. And email has created a situation where the volume of documents has increased exponentially. It's not unusual to get a request for email that contains tens of thousands of emails, and then somebody, our attorney, has to sit and read every one of those before they're released to ensure that we're not violating somebody's privacy, we're not providing something that is protected by the attorney-client privilege, or that one of the other exceptions applies. So you can see that would take a huge amount of time to do, and that's not just one request or multiple requests like that a year. I say that to make you aware. I'm not complaining about it because that's our job, and we're happy to do it, but I want you to be aware of the volume here. We have a duty as a city, as a California government agency, to respond to every Public Records Act request. And who can request a record? Virtually anyone. They don't have to identify themselves. They don't have to give a phone number. They don't have to give an address. They don't even have to give an email address, especially with the electronic platform. They can log on to there, ask for records, and we post them on that platform. So anybody can go and do that. What do they want the records for? Doesn't matter. The reason that they want the records is completely irrelevant. So there are sometimes public officials, especially elected officials, will complain that the public is utilizing the Public Records Act request to harass them. Guess what? That's legal. They can, if that's their intent, again, totally irrelevant. They can definitely do that. Everyone's entitled to the same access. Doesn't matter who you are. The form of the request doesn't matter. The content of the request, the timing of the request. If somebody makes a request and we don't understand what it is, the law requires us to reach out to that person and assist them in making their request. It's often not possible, of course, with an anonymous requester, but that we are required to do that. Okay, this could potentially impact you. It's impacted a lot of boards and commissions as well as the City Council. There was a case, a Supreme Court case, California Supreme Court case, called City of San Jose versus Superior Court. So there was a requester in the city of San Jose named Ted Smith. He sought a writ of what's called a writ of mandate, which is a court filing. It's like a lawsuit, compelling the city to fulfill his requests. What he had asked for were the emails, I believe it was the mayor, about a particular development project. And he was entitled to the emails from the city email account, but what he wanted were the emails concerning that development project that were on the mayor's personal email account. And so the law used to be that if it was on a personal account, that was not a public document and therefore not disclosable. Well, City of San Jose got sued, and guess what? They won in Superior Court. San Jose said, hey, they're not public records, we have no obligation, court agreed with them. But it got appealed all the way up to the Supreme Court. The Supreme Court said, hey, wait a minute here. If you're talking about city business on your personal account, you can't use that personal account to hide the people's business or to hide records that really belong to the people. So what the court said in City of San Jose is, if a member of the public asks for the emails on an elected official's personal email account, that elected official is obligated to search their email account, find the records requested, and provide them to the requester. That's been extended now, not just to elected city council members, but to every employee of the city, as well as every member of a board and commission. And it's also been extended beyond email. It now applies to text messages. It also applies to your voicemails on your personal phone. So don't be surprised if someone takes an interest in what you're doing and somebody makes a request for emails about a particular topic, and they include a sentence that says that we'd also like the emails and text messages that are contained on the personal devices of each of the commissioners. That's happened more than one time here. Happens all the time, as a matter of fact. Not everything is subject to disclosure that way, so we're not obligated as staff in the city to search your personal devices. We leave that up to you, and the court says that's okay. But what we will ask you to do, if that happens, is to sign an affidavit under penalty of perjury that you've done it, so that we can provide that to the requester, where you would sign there. For example, if you don't have any records, you would basically check a box that says, I don't have any records, and you'd say, that you'd sign it under penalty of perjury and give that back to us. Not everything is subject to disclosure. The concept of being related to public business is not always clear. There are some gray areas there. For example, if I send an email to one of my coworkers saying one of my coworkers is a dummy, that's probably not a public record. That's just me being kind of gossipy and stupid. So that's probably not a public record. But an email to a superior reporting a coworker's mismanagement of a project probably is a public record, because that's the people's business now. You're not going to have to worry about this one too much. And I apologize, this is a all-purpose presentation that we use for everybody. Here we go. What's the city's responsibility? So unless the search for public records is overbroad or unduly burdensome, agencies are obligated to disclose all records they can locate with reasonable effort. It doesn't require undertaking extraordinary or extensive or intrusive searches, but we have to use reasonable effort. And reasonable effort would be, for example, we have a system that we use to search emails with keywords. That's reasonable because it's easy to do and it doesn't take a lot of time to do the search. There's another case out there now related to that. It used to be, if we had tens of thousands of emails, we would say that the search is overly burdened and we wouldn't do it because it was just too much work and too much staff time. I mentioned earlier, we have requests for 40,000 emails pretty frequently, and I have a lawyer sitting upstairs full time reading all of those. We used to be able to basically say, no, we're not doing it because it's overburdensome. Unless you can narrow it with a different keyword search or give us more information so we can narrow it down to a reasonable number, we just don't have the staff time to do it. Well, a city got sued for doing that, and the court came back and said, hey, you know what? You only asked for 40,000 emails. We think that's reasonable. You can do that. And so now that's out there. At least 40,000 emails is considered reasonable by the courts, and they didn't put an upper limit on it. They said in that particular case, well, in this case, there's 40,000, we think that's reasonable, but they didn't say what was unreasonable. So there's no cap on that. So at this point, we don't know. I still say that if somebody asks me for 100,000 emails, I'm probably going to say, look, that's going to take months for us to process, and we just don't have the staff time for it. And I would probably say that it's overburdensome. But I don't know if a court would agree with me because that hasn't been discussed by a court yet. What are some of the common exceptions? I mentioned attorney-client privilege earlier. Attorney work product is an exception. Attorney bills, retainer agreements are exceptions. Requesters can get limited code enforcement records that are related to criminal activity. There's something called deliberative process privilege, where if there's a string of emails among staff trying to figure out what to do about something, that's potentially deliberative process privilege. Drafts of documents, if they're not kept in the regular course of business, do not have to be disclosed. I'm going to skip over that one. What's a reasonable effort? What about my private email and social media? That's the other thing I should have mentioned earlier with San Jose. Your social media accounts are subject to the Public Records Act as well, if you discuss city business on them. So a couple of cases I'll talk to you about just a little bit to try and reinforce some of this. This one's called Community Youth Athletic Center versus City of National City. And these are all court cases in the appellate court that are precedential cases. In other words, they're cases that lawyers look at to be able to interpret what the law says, because the courts interpreted it for us. So they're precedential in that they apply to the law throughout the state. So in this community youth case, the city hired a private consulting firm to prepare a blight study. Upon filing public records requests, the property owner learned that the consulting firm had destroyed some documents after completing its work. Uh-oh. The court concluded that the evidence of blight was insufficient under the law, and that detailed maps provided to the public a week before approval were untimely under the law. The documents requested were public records, as defined by the Public Records Act, and the city's efforts to produce them were inadequate, according to the court. The city did not deliberately withhold public records. Rather, the court found a due process violation that through neglect, indifference, or inadvertence in conveying the request to the respective custodians of records, the city did not diligently search for and produce the requested documents, which were known to exist and under the control of its employees or consultants. So even though we hire a third-party person that's not a government employee, and they have some of our records, those are still our records, and they're still public records, and still have to be searched. In this case, the city didn't bother to tell their consultant, hey, you need to save those for us. So the consultant was unaware, and that was put on the city because of neglect. They should have told them, you saved those records. Another case, California First Amendment Coalition. The coalition sought to force the state governor to release public records containing information relating to applicants for a vacant position on a local board of supervisors. The governor took the position that they were exempt because correspondence under the law for governors correspondence, and also pursuant to the deliberative process privilege. The court ruled in favor of the governor. Even though that's the case, I think that that law is slowly changing. So the governor's position was, look, I can withhold information on who I'm appointing to what boards. There's some other cases dealing with the governor's schedule, his calendar. The old law is that's not disclosable. With the advent of the electronic age where everything is instantly available, I think we're creeping more toward making those documents disclosable, with cases like San Jose saying you've got to search your personal devices now. The city has an administrative rule that sets a policy for records in the city of Vallejo. The rule states that you have to maintain the security of records. So if you have records, that's the other thing I wanted to mention. If you have records on your personal devices dealing with city business, you cannot destroy those or delete them. You have to keep them, just in case they're asked for. Destroying them will get you in trouble. That's why I think it's a good idea for all of you to create a very specific email address just for what you do here. You can create a Gmail account, or there are other ones out there that you can create for all of your communications concerning what your work is here. If we ask you for records, we ask that you promptly respond to us, that you undertake a reasonable effort to search and disclose public records that you might have in your possession. Again, that's going to be on your personal devices. That you certify the search, which means we want you to sign the affidavit, that you give us the records, of course. And here's the other thing. Each of you individually, because you're on a city board and commission, a member of the public can give you a request for records, and it's just as valid as them putting it on our electronic platform. So requests can come in any form. Somebody hands you a piece of paper saying, I want these records, you've got to do something with it. Typically what you would do is give it to your secretary, and they would know what to do with it, all right? Or you could give it to the city clerk if you happen to see her. But you have to do something with it. And requests can come in on an envelope, written on an envelope. They can telephone them in. So you can get a verbal request for records, and that's a valid request that you have to deal with. They can text a request. So the law requires them to request them any way they want to, allows them to do that, rather. So if you do not sign our affidavit and you essentially refuse to cooperate with us when we ask you to search your records or your personal devices, we're going to probably tell the requester that you did that. Depending on who it is, that can result in a lawsuit. If you were to get individually sued by a requester for withholding public records, if they win, they're entitled to collect attorney fees. Attorney fees, as you might know, can be very expensive. I can tell you that we as a city have been sued over the Public Records Act, and I have paid attorney, not me personally, but we've paid them through the city anywhere between $50,000 to $100,000. I've never seen one less. So it's a big deal. If we ask you for records and we ask you to do an affidavit, you need to cooperate with us on that because we're really trying to protect you. Again, you can't destroy records. The city has a records destruction policy. Most records have to be kept for at least 2 years. There are many that have to be kept much longer than that. There's a general prohibition at the moment against destroying any record in the city because we had some issues with that a few years ago about some records getting destroyed that shouldn't have been destroyed, so we just put a moratorium on anything being destroyed. Plus, it's a violation of the law and is a felony offense punishable by prison if you destroy public records. Okay, we'll talk about this briefly. Conflicts of interest. So, all of you are supposed to fill out every year something called a Form 700. I'm sure you've seen it, where you disclose certain information, financial information, typically, to the public. And those forms are available for the public to look at. And the reason for that is conflicts of interest. They want to make sure that the representatives who are on this board don't have a conflict of interest with people who come before you, for example, seeking your approval. For example, tonight you're going to have a developer ask you to hold what's called a TEFRA hearing and give your recommendation to the city council to approve some bonds that they're going to use to build some affordable housing. If one of you has some kind of financial relationship with that particular developer and you're here to vote on that matter, that is very likely a conflict of interest that you would need to disclose and then recuse yourself from participating in that process. All right, so that's an example of one thing. There are lots of other things that could happen that would create a conflict of interest. So the law that covers conflicts of interest in California is something called the Political Reform Act. And what the Political Reform Act seeks to do is to bring a degree of credibility to government by providing that those who hold a public trust must act and appear to act ethically. Erosion of confidence in public officials is detrimental to democracy. To maintain confidence and to avoid public skepticism, conflict of interest must be shunned. So the Political Reform Act covers a wide range of things. Campaign finance, you guys aren't running for these seats, so you don't have that. Lobbyist registration and reporting, more than likely doesn't apply to you. Political mass mailings at public expense wouldn't apply to you. Post-governmental employment, the main one that's going to apply to you are the last two there. Gifts and honoraria given to public officials, financial conflicts of interest by public officials. This is the basic prohibition right here. No public official at any level of state or local government shall make, participate in making, or in any way attempt to use his or her official position to influence a governmental decision in which he or she knows or has reason to know that he or she has a financial interest. Really pretty much common sense, right? So it's not that difficult. Although the laws are difficult and complex, the concept is not that hard. If you think you have a financial interest in something, you should not participate in whatever you're being asked to do. So when do you have a financial interest? If the decision you're participating in, if it's reasonably foreseeable that the decision will have a material financial effect distinguishable from its effect on the public generally, in other words, it's going to affect you differently than it would anybody else out there. And it can be a negative effect, by the way. It doesn't have to be positive. It doesn't have to be money in your pocket. It can also be the loss of money. That's still a financial impact that doesn't affect the general public the same way. An example of that is you don't approve contracts here, you provide recommendations, but let's just say that you did. If somebody came and wanted, let's do a different example. This is an easier one. If there's going to be a street project and your house is within 500 feet of where that street project is going to be, that's a disclosable conflict of interest. And it's a conflict where you would have to recuse yourself from the decision. Now, sometimes street projects can actually increase your property value. But sometimes some of the projects that we would do as a city could decrease the value of your property. Let's say they were going to eminent domain a piece of property and dig a big irrigation canal through the corner of your backyard. That's probably a negative impact on your property. That's still a disclosable conflict of interest. I'm not going to get off into the weeds in this too much. What I'm going to tell you about it is If you have any feeling at all that you might have a conflict on something that you're considering or that you're going to deliberate on the agenda, mention it to the city attorney's office. You can reach out to me or you can reach out to Shari and she'll get in touch with me and let us evaluate whether you do or not. If you do, we will tell you what you need to do about it, whether that is to step down or whatever that is. And there were some other things that can be done as well that I'll mention in just a moment. Again, the laws are very complicated, and I'm not going to get off into that too much tonight. I will mention this. So economic interests can relate to real property, personal finances, sources of income. And it can also be the real property, personal finances, or sources of income from your spouse or your children or anybody that's close to you, family-wise. Gifts. I will mention this. So let's say somebody sends one of you a case of wine. We're in the wine region, right? So they send you a case of wine, and wine here is really expensive. I know that because I bought some the other day. So they send you a case of wine that's worth, it says $460 here. That number's actually gone up a little bit. It's over $500 now, I think it is. So if you get a gift that's over $500, you have to report that gift on your Form 700. You'll see on there's a form for gifts, so you have to report that. And actually, you're not supposed to even keep it if it's over the threshold amount. You have to send it back, or you can donate it to charity. Those are the two options. Okay, but you still have to report it, that someone tried to send you a gift, and talk about what you did with it. So I'm not going to get off into all of this. All right, I will mention this. There is an entire public agency that's devoted to the Political Reform Act. It's called the Fair Political Practices Commission, or FPPC. One of the things that you can do if you're facing what you think is a conflict of interest on a matter that's coming before you, the FPPC provides two different types of advice. They will provide informal advice by email or telephone, or they will provide formal advice. Now, there's a difference between those two. The informal advice is just to help you make up your mind what to do. The formal advice is a written letter where you write a letter to them explaining the circumstances in detail. They will provide an advice letter back. And when you get the advice letter back, you're entitled to rely upon that advice letter. So that means later on down the line, if somebody accuses you of violating the law for having a conflict of interest, or somebody wants to prosecute you for violating the law, you can pull out that FPPC letter and say, no, I got the advice from the FPPC and they said this was okay. You're entitled to rely upon that, and you get that protection, that immunity there, which is one nice thing about it. The only bad thing about it is it takes a minimum of 21 days to get the advice back from them. And we do it from time to time. We've done it here for elected officials, and I've done it for elected officials at other public agencies that I've worked for over the years. We can also assist you, the city attorney's office can assist you with obtaining FPP advice if you want to do that. So, but you have to let us know, right? So if you feel that there's a problem, and we may actually advise you to do that depending on what the issue is. There are other considerations with conflicts. It's not just the Political Reform Act. There are other sections of the code. Government Code Section 1090, that has criminal penalties associated with it. That one has to do with influencing the approval of a contract by a legislative body. If you have a financial interest in a company, you don't disclose it, and that company comes and wants to get a contract approved, you can get in trouble for that if you vote on it. You can also get in trouble with it if you try to influence it. It used to be officials just had to step down, right? Or they could recuse themselves and stay on the dais years ago. That's not possible anymore. Now when you recuse, you have to walk out of the room, because what was happening is the recused official would stay on the dais or even step to the back of the room, and they would, hand signals, make faces at people to try and influence the outcome of the vote. Any questions? I know there's a lot of material.
Through the chair. So thank you for that presentation. I have a couple of comments.
Sure.
And then several questions. So forgive me wanting to make sure that I respect the process. We've had several city attorney liaisons in the past year. I think you are number 3. I'm pretty sure. Shari, is he number 3?
I am your assigned attorney, and I have been since I've been here. I have other assignments, and sometimes they're conflicted because we have a lot of boards and commissions in this city.
I can imagine. I'm not
Yeah.
being. I'm actually not being
Yeah,
trite.
but I am
making a statement.
I am the person that's responsible for you. So if
You
somebody
are.
else comes here, I've sent them here.
Okay, that's good to know.
Sure.
And when they're not here, it's because you didn't send them here?
We haven't had enough staff to cover all of the meetings that we'd like to cover.
I was chair for 3 years. I saw a city attorney maybe once or twice.
Sure. Right.
I'm sorry, I saw a city attorney 3 times.
3 times?
This is the third time in 5 years.
So we are.
This is not my question, though. I'm just making a statement.
Yeah, I understand.
I really don't want you to be, I don't want to interpret your responses as being defensive, but I'm starting to think that a little bit. But just know, in 5 years, there's been a representative from your office 3 times.
Sure.
So my questions are kind of statements and questions. First statement is, given the fact that we're going through the Browns Act, and I've gone through the Browns Act, I think twice, because I've been a commissioner for about 15 years. Normally, there's a separate training for the Browns Act so that the new commissioners know that it's going to take a little bit longer time to go through their normal meeting, and they can plan their lives a little bit better.
Mm-hmm.
Was that not a consideration for tonight's meeting?
It's not a consideration that I gave
No,
you.
no, what I'm saying is,
Yeah.
normally the training takes place, I think, in the library underneath. We know that there's a training. We get the presentation more than a few minutes before sitting down on the dais. So I'm asking the question, which is, did we not know that we were going to do Browns Act training tonight? Because this is a much longer agenda for most of us, given the fact that this is also a very special time of year. So we had plans, and so therefore, if you look at this agenda, there's nowhere on here where it says we're going to go through 85 slides in about an hour and a half. So did we not know that we needed to do Browns Act training is the question.
Well, yes.
We did
I
know.
did. It's on the agenda. So of course we knew.
Right, so the agenda says it's training, but there's a difference between the entire training of 85 slides and an introduction for new commissioners. So my question, let me get to some level of specifics. My question is, we got your presentation, the presentation was received when I sat down. I didn't have it in advance.
We typically provide the slides even to the city council at the meeting. Yes.
So this is normal practice?
Yes.
Okay. So then let's go into the next piece. Can you tell me a little bit about my question is about whistleblowers. If there are knowledge of a conflict of interest, but is not revealed to the city attorney's office, does that fall under whistleblower action? Is there a process in here for whistleblowers?
I'm not sure I understand your
Sure.
question.
So if you know that a commissioner or elected official has a direct connection with a conflict of interest, maybe there's a contract, in this case, it's a piece of property, for an example, and they did not disclose.
If I knew it personally?
No, if a member of the public or another commissioner knew that there was a connection there for another elected official that was not disclosed, is there a whistleblower process?
They should speak up because there's no way anyone will ever know unless they do.
Okay, that's perfect. Okay.
Yes.
So now that I know that I'm talking to the person in charge, it makes my questions a little bit more specific. Next question, through the chair. Next question. Is there a process underway where the Browns Act, I think the training requirement, is it every 2 or 3 years?
There isn't really a requirement to do it. We try to do it when new members come on boards. It works out to be around 2 to 3 years, depending on the commission.
Okay. And given the fact this is a presentation that you use for everyone, are there any unique considerations for commissioners when you say standard process? The other commissions have emails, we've noticed. We do not. So when you have that statement in your presentation, talk to me about that. How does that work? Why hasn't this commission been given an email account?
That is the policy of the city. I have nothing to do with that at all. So they do give, when I say the city, I'm talking about the IT department. They have been directed to give emails to the Planning Commission, and I think the Police Commission now has.
Oh, there's several. There's
Yeah.
several commissions that have.
But most of them do not have city emails, and that's pretty normal.
Okay, so I guess I'm conflicted by your answer. I don't understand your answer. Slow that down for me. Are you saying it's the process that there aren't emails given, or that there are?
Some boards and commissions have emails. There are only 2 I know of. That's the Planning Commission and the Police Oversight and Accountability Commission. Those 2 get emails. Everybody else, they don't get emails. That's why I mentioned earlier, it's a good idea to go and create a
Yeah, I'm
Gmail
actually-
account.
yeah, I agree.
Just for this.
Okay, next question. Given the fact there's a Browns Act and compliance is in here, and there are several pieces of this commission, since I now know that we are your direct focus, although you don't have much time, where contracts have expired, or we've been asked to look at contracts where the vendor's not qualified, or they haven't completed their due diligence paperwork, yet we put them into position. Is that also with your approval?
You'd have to be more specific. I'm not sure I understand what you're asking me.
I'm talking about the navigation center.
Correct me if I'm wrong here. I think it was pertaining to Broadway project when Firm Foundation entered contract with the city. Their 990s with the IRS were not up to date.
I'm not the one who did the work on that particular project, but generally, yes, we'd be responsible for those contracts.
So then my follow-up question is, I think I don't have questions, I have more thoughts. I don't think I have questions, I think I have more thoughts.
Sure.
But thank you.
You're welcome.
Thank you, Chair.
Through the chair, I want to thank you also for your presentation. I've already done this training, and so I wish, just as like a note, I wish we would have had this on the agenda a little bit earlier. And it would be really helpful if it was tailored. I feel like a lot of it, I learned a lot. I'm not saying that I didn't learn a lot.
Sure.
But I wish that we could have, did this have to be on public record that we did this training in a meeting? Or could we have done this in a different setting? Just because I want to hear, I know we have some people from the public here and we have a couple other items. And I know sometimes it's, there's some people waiting to talk, so.
Sure.
Is there like
We always do the trainings at public meetings.
Okay.
Yes.
And
If we're
then-
going to do it in a group, we have to do that.
Perfect. And then secondly, all the attorneys that work for the city do report up to you, or is there someone else?
No, I'm the number 2 person in the office. Veronica Nebb is the city attorney. She's my boss.
Okay. Okay, cool. Thank you so much.
So just as a matter of correction, my Browns Act training was not in a public meeting. It was in the library across the street, and it was not recorded.
Then I didn't give it to you.
So thank you, Chief City Attorney Reisner.
You're welcome. Thank you. It's my pleasure.
Any other questions? So we'll move on with agenda item 5. That's the report of the City Council liaison. And I see our liaison here. Dr. Ledesju, any report? No. So no report. Item 6 is the community forum. So anyone wishing to address the commission on any matter for which another opportunity to speak is not provided on the agenda, and which is within the jurisdiction of the commission to resolve, is requested to submit a completed speaker card to the staff secretary. When called upon, each speaker should step to the podium, state his and her name, and address for the record. Each speaker is limited to 3 minutes pursuant to Vallejo Municipal Code Section 2.20.300. Anyone wishing to make comment?
Through the chair, currently do not have any members of the public signed up to speak for the community forum, either online or in person. Unless there are people with their hands raised that want to speak in person, nobody signed up at the terminals.
Okay. Thank you, Manny. So we'll move on to item 8, which is the consent calendar and approval of the agenda. Subsection A is approval of the agenda.
Through the chair, can I request that we reverse, for the agenda, could we reverse action items A and B? Because we have a couple of consultants online for B. So if we could have action item B first and then A second. That's just the only change I'm requesting for the agenda.
Any objections to that? No. So we will accept that recommendation and take item B before A. So that's 9B before 9A.
Through the chair, yes.
Thank you. So back to the agenda. Is there a recommendation?
I make a motion to approve the meeting minutes from March 5th, 2026.
And the agenda? You can do them together if you want in one motion.
As well as the agenda.
I second.
Commissioners Bundy,
Aye.
Cassidy,
Aye.
Daniels,
Aye.
Jackson,
Aye.
Stuland,
Yes.
Vance.
Aye.
Thank you.
Item 9 is the action calendar. So members of the public wishing to address the commission on action calendar items are requested to submit a completed speaker card to the staff secretary. Each speaker is limited to 5 minutes pursuant to Vallejo Municipal Code Section 2.02.420. Any speaker cards?
Through the chair, do not have any members of the public currently signed up for this item, nor any hands raised online.
Thank you. So then we're going to do item 9B here, which is the recommendation to adopt a resolution recommending conducting a public hearing and approving the issuance of the California Municipal Finance Authority qualified 501c3 bonds in an aggregate principal amount not to exceed $20 million for the purpose of financing or refinancing the acquisition, rehabilitation, development, and equipping of Sereno Village apartments pursuant to the Tax and Equity Fiscal Responsibility Act, TEFRA, with no financial liability for the city. And we have a presentation, Sherry?
We don't have any presentation through the chair, but if you have any questions, we have Jared Suzuki from CMFA, California Municipal Finance Authority, and Mike Rogers from Mike Rogers Consulting. So our recommendation is to adopt a resolution recommending the public hearing under TEFRA. That public hearing will be at the City Council, scheduled for April 23rd or 28th. It's the regular meeting of the City Council. And then at that same meeting, approving the issuance of the bonds by the CMFA for the benefit of Eden Housing, California nonprofit public benefit corporation on behalf of Eden Sereno Village LP, to provide for the financing of the project. Such adoption is solely for the purposes of satisfying the requirements of TEFRA, the code, and the California Government Code Section 6500. So if you have any questions, we have them online.
Any questions? I guess the one question I have with the rehabilitations, is this going to impact tenants' share of rent in any way?
Hey, this is Michael Rogers from Eden Housing, and no, it will not.
Great, because it looks like substantial upgrades to the property, so that could be really good news for tenants that get a better standard of living for the same cost.
Yeah, the rents will remain unchanged, and they will continue to be regulated the way they are now for the future.
Through the chair. I do have a question. I was wondering if anybody would have to vacate their current residence in order for these renovations to occur? And if so, what are the plans to either provide them with temporary housing or to bring them back into their current apartment after it's renovated?
Yeah, that's a very good question. So we will be converting some of the units, about 10, to current accessibility codes, and we will be temporarily moving people out of their current apartments and housing them in some current vacant units at the property. And while the work is happening in their units, they'll live on the property, but in a different unit. And there won't be any additional cost to the households. And we also have a specialized relocation consulting firm which makes sure that the communication with the households is done properly and consistently, and to the letter of the law. So the short answer is not all of the units are going to be completely renovated on the inside, so not everybody needs to temporarily move out of their units, but some households will.
Through the chair, thank you for your answer. My next question is, when people move or have to be relocated, even within the same apartment building, it does cost them time and money. Will you be reimbursing them for those costs?
We we'll hire movers, and we will, if people desire, we will completely pack their units and unpack their units, both directions, both out of the household of their house and back into their house. And then there is no additional costs that they're being asked to bear. Does that answer your question?
Yes, that does, and it is great news. I did just also want to confirm that if they were to have to miss work for any reason to oversee the people moving their property, or if they missed work for any reason due to these moves, would they be reimbursed for hours missed? So if they have an 8-hour shift and they miss 2 hours, would you be able to reimburse them at their normal rate for that of pay?
I don't generally see that happening, but I can get back to staff on an answer to that question.
Okay, thank you so much.
No further questions? Do we have a recommendation?
Through the chair, I make a motion to adopt a resolution recommending conducting a public hearing under the Tax and Equity Fiscal Responsibility Act in connection with the proposed issuance of revenue bonds by the California Municipal Finance Authority, a joint exercise of powers, authority, and public entity of the state of California in an amount not to exceed $20 million for the part of a plan to finance or refinance the acquisition, construction, development, or equipping of a multifamily rental housing project located at 750 Serrano Drive, Vallejo, California. And two, if I may do both at the same time. To approve the issuance of bonds for the CMFA for the benefit of Eden Housing, Inc., a California nonprofit public benefit corporation, on behalf of Eden Serrano Village LP, a California limited partnership or another ownership entity to be created by Eden Serrano Village LLC, a California limited liability company, its general partner, or by another affiliate of the developer, to borrow for the finance of the project, subject to adoption as solely for the purposes of satisfying the requirements of TEFRA, the code, and the California Government Code, Section 6500.
I second.
Commissioners Bundy,
Aye.
Cassidy,
Aye.
Daniels,
Aye.
Jackson,
Nay.
Stuland,
Aye.
Vance.
Aye.
Thank you.
And thank you to the consultants for being online and being available for questions.
Yeah, thank you very much. And frankly, I learned a lot about the Brown Act, so that was great. All right, have a good night.
You put it on your resume. Take care. So item 9A is commission discussion and questionnaire regarding MRG report.
Okay, through the chair. So I just wanted to say that this, just an introduction for item 9B. The city hired a consultant, MRG, that's for Municipal Research Group, to look at the city's boards, commissions, and committees for best practices and recommendations for all of our commissions and boards. There was a report that was presented to the council, and then staff were instructed to ask feedback from boards and commissions, so your feedback can be included in the report. So we had this item on March 5th, and then the commission decided that we put this back here for discussion. We have some of your responses in writing, and you'll see them in the handouts. Through the chair, I can go through the questions, each question, and then the commissioners could respond or add to the responses and discuss.
Can you tell me, through the chair, do we know if all of the commissioners' responses made it in here? I know that for sure I was late, so.
We have 4 out of 6 who emailed me for the responses.
So for the 2 that didn't get a chance to do the questionnaire, can we capture their answers tonight, or
Through the chair, of course.
who are the 2?
Vice Chair Jackson and Commissioner Stuland.
Since you have mine in email, do you need me to go through it tonight, or can you just pull that up for reference later?
We can discuss it tonight, Vice Chair, and I can add it.
No, like, I didn't bring mine with me. I sent them to you. Do you not have them?
I didn't receive them, Vice Chair.
Okay, that's good to know.
So has everybody reviewed this? Any discussion on the items? I mean, the one thing I would say is it seems like the responses here are pretty well aligned with each other. Sort of uncannily aligned.
Through the chair, I'll send you mine this evening, Shari.
We apologize, Vice Chair. Through the chair, Brianna just pulled up the email. We have it on March 25th.
So then, Shari, adding those comments, we then move this on to City Council.
Do you want me to verbally respond right now?
If you wish, Commissioners, to lend through the chair, or we could still accept the responses, it's
Yeah.
fine? Yeah,
I'll email them.
okay.
I have them in a Word document on my computer. I apologize about not sending those.
Thank you. So no further action on that item. Item 10 is written communications.
Through the chair, we don't have any written communications.
Um, Maybe we'll ask if we can, do you have an item to discuss, Councilmember Leteju? And just sort of advice where the best place to put that on the agenda. Could we do that under item 12, other?
You mean the liaison, council liaison? It's on number 5. It can be anywhere on the agenda, it doesn't matter. Anywhere that you'd like for it to be.
Okay, so
It's
then-
at number 5 right now.
Yeah. Could we do that now?
You could go back to it, of course.
Thanks. Report of the City Council Liaison.
Good evening. I just wanted to touch bases after hearing the questions from the commission regarding the training. And I will have a separate conversation with City Attorney Neb and yourself. Because I do, as someone who has been responsible for a commission and a board, and also a part of those commissions and boards, and someone who's an elected official, and someone who's a CEO. I've never sat in an open session and had Brown Acts training. It is a lengthy training, and I think it is really important that when we put it on the agenda, that individuals who are serving, volunteering, understand that it's going to take an hour and a half or so, especially if their commission meetings last an hour, hour and a half, then we have elongated that meeting. So I think we need to think about that. And I myself was surprised. And I'm also wondering how this training can be electronic. Many trainings are electronic that I have attended to meet these requirements. It's either sometimes in person when I've gone to Cal Cities, or prior to that, always done electronically. So as a city, I think we need to think about how that can be done. And you know, you're not the only one making these decisions, so just hearing the comments, I don't know what other comments have been made by other commissions, but I think we can really think about how some of this training can be done electronically. And we do EEO training electronically. There's a host of required training that is done annually or every 2 years online. So I'm not sure how we can reconsider perhaps making this an online training for all of our commissioners, and then it's reported, through the normal process. So your point is well taken and fully understand why you might be shocked at the fact that you're sitting through a long training and not having that information prior to. And generally, anything that's on the agenda, if there's attachments, those attachments generally are there and should be there as a regular course of matter that we do business. So I'm not quite sure why we would not attach the Brown Act training to the agenda as a supplement as part of the presentation. So those are my comments, and I just wanted to come up and make those comments because I do want to acknowledge that I fully heard what was said and fully understand, and the very fact that we have individuals in the audience who may be here to make comments, so forth and on, and generally can gauge how long this meeting normally takes outside of what has occurred today. So thank you very much. And again, thank you all for your time and for your service. I really appreciate it.
Chair, might I clarify something, please? So the training that you got tonight was not my idea. You were the guys who asked me to do this at a meeting, and that's what we did. So we could have done, if you wanted to watch a video, I could have pointed you to a video, but you asked me to be here and do a live training. So that's why I'm here and why we're doing it live tonight. I just wanted to make sure that you were all aware of that, because I certainly understand that you have other things that you like to do and you have lives, but this was something that you asked me to do, and that's why it's on the agenda, and it was asked to be on a regular meeting agenda.
Any comments? No. Thank you. So item 11 is report of the committee board and secretary. A is report of the secretary.
Through the chair, I don't have any reports. Thank you.
B, report of the city attorney.
I want to mention one other thing that I forgot to tell you about during the training. It won't take me very long. And I apologize for the length of the training. It is lengthy. I do apologize for it, but there's a lot of material to cover, unfortunately. So there were a couple of changes I wanted to mention tonight that can affect you and actually are positive for you with the Brown Act. So there's something called SB 707, which went into effect just January 1st this year, which allows a couple of things. So first, it allows you to attend remotely for what the bill calls just cause. So just cause would be things like you have an infectious disease, you have a family member who has an infectious disease or some other disability that needs your care. You've been called to active duty military. So there are a number of different things that would activate this just cause. The way it works is you don't have to post an agenda beforehand wherever you're at, which is what you have to do with the other way of doing remote meetings. With this particular way, if you're sick, for example, you can show up online with the Zoom link, ask the commission to allow you to appear remotely, and you have to give a general reason as to why, so you can say, I'm sick, or whatever you need to say that fits within those particular parameters. So I wanted to bring that up to you in case that happens to you, because we have had some commissioners and other board members and other boards and commissions that have taken advantage of that in circumstances where they've been ill. If you're out of town on city business or commission business, that's another reason. So there are ways to make that happen. Otherwise, the old way of attending remotely is that you have to find a place where you're at that's open to the public, or if you have a hotel, you can leave your hotel room door open. An agenda has to be posted on the outside of the door that the public can see. And it has to be posted in the same amount of time ahead that it's posted here. The catch in that one is, and also in the just cause one, is always on remote hearings, a quorum of the body has to be present physically here. So one or two of you could potentially be attending remotely. So I wanted to bring that up because that is a significant change for you that could be helpful for you down the road. And that's nothing further. That's it for me.
Thank you. C, report of the presiding officers and members of the Housing and Community Development Commission. So I have some items to discuss with the work plan and suggest to start an ad hoc committee, do we need to make a motion for that?
It would need to be on the agenda, and I typically would recommend that you adopt a resolution doing that because you're appointing members, and then we have a record of who the members are, and also the other catch with the ad hoc committees, they have to be a limited duration, and you have to specify a very specific task for them, and we do
So-
that with a resolution.
So then, Shari, for next session, can we agendize forming one or two ad hoc committees, possibly one for the presentations to the City Council and Housing Authority Board, and a second ad hoc committee for the build relationships and collaborate with other commissions? So a partnership ad hoc committee and a reporting ad hoc committee? And how about standing committees?
Standing committees are permanent committees, essentially. Unless you have a good reason for doing one, I wouldn't typically recommend it because it creates additional work for staff because those have to be noticed. There has to be space found for a public meeting, and that's becoming more and more difficult to do.
Yeah.
But if you have a really good reason for one, of course, we can
Well,
talk about
and
it.
the reason I ask, I know that currently the federal housing policy is changing so rapidly that some of the federal policy changes are really impacting tenants. And I've personally heard from a couple different tenants in the city of Vallejo who have been financially impacted by some of the changes, and they don't necessarily feel like they get the best response when they reach out to the housing authority. So thoughts about a standing committee to address tenant concerns and potentially agendizing that as a discussion item?
Through the chair, a standing committee, does it have to have like one agenda to do work? Can it have multiple layers? Like, for instance, all the changes, and there's changes how it relates to the tenant. There's changes in how they relate to potentially their landlord. How do you address those issues? Can it have, I don't know if that's multiple strategic levels, or is it just one per standing committee?
So the rules for standing committees are the same as they are for everybody else. If they're going to hold a meeting, each item they're going to discuss has to have a description that is specific enough to identify to the public exactly what they're going to talk about. It doesn't have to be all the details, but it has to be able to alert the public, give the public a really good idea about what's going to be discussed.
That's just, yeah, that makes sense.
So, Shari, at a future meeting, could we agendize an update for the commission on how tenants file grievances or concerns with the housing authority, and then how the housing authority then reacts to those items? Does that make sense?
This is Director Jones. Through the chair, may I answer regarding the process?
Yeah, that would be, thank you, Director Jones.
You're welcome. So the program is designed for any adverse action that the Housing Authority has taken regarding rent increases or impact to the family's composition or voucher size. The family has an opportunity to request for an informal hearing. That information is provided to them on the documentation that they receive at the time that the change takes place. in regards to when noticing individuals of our changes, each year we bring before the commission and the board our administrative plan, which is our policy that we must follow as it relates to administering the program. In all communication that we have, when we present the admin plan, is available the summary of changes and the actual document. And the actual document is on our website. And also it's available at our office, and it's also available if they call and request a copy. So there are systems and processes in place currently that address when a family would like to request an informal hearing. There are times when the request is asked of us, the Housing Authority uses a third-party entity to conduct our informal hearings on our behalf. Those individuals have a schedule and they're conducting hearings for multiple housing authorities. So we have to schedule according to their availability. So there may be a delay in responding as far as conducting the informal hearing, but there is no delay in trying to get the hearing scheduled. It's just a matter of when. This can actually happen a month out or 2 months out, be based on the hearing officer's decision. Availability. It's kind of difficult to schedule immediately within 10 to 15 days and schedule and conduct a hearing because of the volume that's presented from multiple housing authorities requesting hearings.
Thank you, Director Jones. Ask through the mic, please. Discussion.
Through the chair, are you still wanting to have a standing committee to discuss the changes?
Well,
Or do you think?
so I think the item would be to agendize discussion of a standing committee. Right, because we would want to understand what the benefits and what any drawbacks of forming a standing committee are.
Sure, and that's how it would need to be agendized anyway, because you have a two-step process to agendize items. So it would be agendized to agendize it at some later date, to decide whether you want to agendize it, right?
So can we agendize to agendize it at a future date? Shari?
Yes.
Thank you. Any reports of current ad hoc committees? No current reports. 12, any other items? And with that, that brings us to number 13, which is the adjournment. Thank you all for being here.
Minutes, meeting 4:23. Yes. Agendas to agendas. Thank you, Randy. If you have a special meeting, will you also be attending? Okay. Yeah, I'm sure.